Welcome into Mock Trial Masterclass, your guide to controlling the courtroom. I'm Luke, and in this episode of the Mock Trial Masterclass podcast, we're going to talk about how you can control the courtroom like a mock trial master. This is the Mock Trial Podcast that's for you. It's not for me, it's for you. Our only goal here is to help you get better at your craft, to help you improve. And today, we've got an awesome guest who's going to help us do that. Here's the thing about speeches in mock trial, guys. They're really, really important to get right. Opening statement sets the tone for your entire case, and closing arguments is where you put a bow on your entire case, and it's really, really important to get them right. So joining me today is someone who knows all about getting them right, and that's what we're going to dive into. It's, did I get this right? 3-time All-American attorney, Travis Harper?
Yeah, 3-time attorney. Yeah.
Golly, man, how do you make that happen?
It's really interesting. So the way AMTA works is that you get an additional All-American simply by being in the final round. So like there was someone on our team that got 3 All-Americans in 1 year.
Oh my gosh. I had Liz Grant on a few months ago, and I introduced her as 2-time All-American. I thought that was like a big deal enough.
It is a big deal. It is a big deal.
And 30 ranks at the 2022 National Championship Tournament. That's perfect, right?
Yeah. It was a 3-ballot tournament. It was a crazy experience. It was a crazy time.
Well, we're glad to have you here to talk with us about opening statements, closing arguments, and what it takes to deliver both at a high level. And I'd love to hop right in. Well, actually, I was going to say let's hop right into opening, but I'm going to ask you this first. As someone who has done both, I've done both, you've done both, open and close, which is your favorite?
This may be a hot take, and I think that my favorite at its peak is opening.
Okay.
I think that I prefer the average closing, perhaps, doing the average closing to the average opening.
Okay.
But I think the best openings that at least I've felt like I've ever performed have been like some of my best mock trial feelings ever.
Yeah.
Because I think there's a kind of like intrigue and like beginning of the trial kind of like nerves that I think cause you to actually perform like at a like very high level because your brain is a million miles a second, that like creates these like masterpiece like 5-minute speeches that like, are just so fun to listen to. And I like love listening to openings. And I feel like they're also one of the most formulaic at times parts of the trial, but I think it does not make it any easier to write.
I agree with you 100%. So when I was in high school, I was the closer. I closed in every high school round that I competed in, and I didn't open until I got to college. And when my coach in college was like, all right, you're going to open on this side of the case, I was like, but I'm a closer. Like, that's what I do. That's what I know how to do. And I say now that the most fun I've ever had in mock trial was my junior year of college at Belmont. Well, I think it was a plaintiff opener and a defense closer. So I got to do both. Yeah. And it was so fun to be able to get both sides of that. But if I had to pick today, it would be open, even though technically my background, from high school would probably say I'm a closer. That's certainly what I've done more. It's like you said, it's so much fun. You get to set the tone for everything. You're the first that they get to hear. It's really powerful, I think.
Yeah, no, it is. And I was also mostly a closer. I only opened in college for my senior spring, and I still ended up closing for nationals. So like I definitely was much more of a closer. Oh, and I also opened my freshman year. But I think that my most fond like performance memories, I feel like, have been openings, honestly.
and that's a great segue into talking about, what makes a great opening statement. And there's a story I want to tell as we start, which is that one of my high school mock trial coaches, who I now have the privilege of coaching alongside, when he was coaching Vanderbilt mock trial years ago, he decided that he was going to see how opening statement affected the rest of the round. Did the team that went open, how often did they go on to win the rest of the round? So he, for a while, took ballots, and the conclusion that he came to after doing the math and looking at was that 80% of the time, 4 out of 5 times, the team that won opening won the round. And it didn't matter if it was a lopsided round with a really good team against one that wasn't so good. If it was a really close round, the team that won opening 4 out of 5 times won the round, which leads me, Travis, to say, as we open this discussion, do you win or lose the trial and opening statement? I mean, if that's the statistic that we're looking at, I mean, there's certainly a lot left to come, but man, it's crucial that you get this part right.
No, I 100% agree. I think the openings are more important. I am on my team when I was coaching and when I was captaining, like openings they weren't more important than closings, but I think that I definitely paid a lot more attention to the openings because getting them right is so important. You know what I mean? Like you have to be and they're so detailed. I think sometimes closings kind of do their thing, right? Like sometimes you have that closer on your team that can like pull out a few good lines and like have the intro and everything, and it's going to sound good and it's going to sound flashy and it's going to be enjoyable. But an opening has to be perfect every time, and it has to be extremely well thought out, and especially relative to your theory and how you want to like frame the trial, not just like in terms of your facts, but also like emotionally and like morally, and how like you want people to begin to look at the facts that you're going to present, and I think because reasons it's like so important for framing. I think mock trial is all about framing, and I think opening is like the epitome of framing.
So before we get into content, based on that, I want to ask you this question, because a lot of coaches listen to this podcast, watch this channel, and I get all the time people commenting, I'd love more tips for coaches. And so here's a question we can talk about for coaches, which is, if you're coaching a team and you've got just one of those really, really stellar attorneys where it's just obvious, they're head and shoulders above the rest of the team. Not saying the rest of the team isn't good, but you've got a star player on your team. Do you give that star player the open, or do you give them the close? Because conventional wisdom, I feel like, is you give them the close, but I tend to disagree.
I think it really depends on the competitor. I think different competitors are suited to the different speeches, honestly. I think there are some competitors that are so much better when they're completely scripted, right? And that's not even a bad, I'm not even saying that in a negative way. Like there's just some competitors that like to have their entire script down packed, and they have the flexibility to adapt if they need to, because obviously you have to adapt, but they prefer to have that script there. I felt like I was more of a competitor that was much more about like trying to vibe with the trial in the moment and really the trial and like improv, and like not that it's not like I came into trial without content, but like I was kind of one of those competitors, I felt like, on the team that like everyone knew that there was a possibility that like what I had written like might not be said.
For sure.
Else that was really great that came up. And so I think that like if you feel like that competitor will suit well with that kind of detailed like preparation and choreographing of movement and space and all of those very small things that go into open, I think then they're perfectly suited for opening. But if you feel like they're a competitor that's going to feel very constricted by that and feel like they're going to be stifled by that, I feel like they'll probably be better for closing. But I think that when it comes to like choosing your like competitor that is the most consistent, I've always said put your most consistent person on opening, which may not necessarily be like the like person with the highest highs, but the person that always gets it right, then I think they're the best opener. And then honestly, when I think of that, I think of my opener from Harvard, like for like 3 years when I was competing, Jessica. She was like, everyone always says that her thing was that she was perfect. Like she was perfect. That was the one adjective that anyone would ever say about Jessica. And like every time we were in the national final, she was the opener. And like she always, in one of those years we won. So I think, it's really important.
I think that's a really good point, and I'm excited when we get into closing in a little bit to talk about the balance between scripting and being responsive in closing, because I think that's a huge point. But for now, you brought up a second ago that opening statements tend to be very formulaic, and you're right. I mean, I've seen like memes and TikToks making fun of the traditional mock trial opening statement, and there are a lot of directions you can take it, but I tend to agree with the formula, which tends to be you tell the story of the case, whether it's you're the plaintiff or prosecution and you're saying, here's what the defendant did, or you're the defense and you're saying, here's what actually happened, right? You're telling the story of the case. You're previewing the trial, both through the law, saying, here's what the law is surrounding this case, and through the witnesses, here's who you're going to hear from today, and then wrapping it up with a call to action as your theme sort of weaves throughout all of that. That sort of formula is really unavoidable, right?
100%. I think, especially at that high level, like I think that's 100% the structure. I think the minutia of what each of those parts look like can be very, very different.
Mm-hmm.
I think there's lots of regional preferences and just like
Yeah.
personal preferences that people have to that effect. But I think the general structure of story, law, evidence, get like verdicts like that is something that will never change, because I think that's just how you have to hit everything. And I feel like that's the only pacing that works. Like I feel like a lot of times I see like the law at the very end of the speech and I'm like, ugh, I wish I could have heard that before I heard your evidence, so I know how to understand your evidence within of the elements of the case. And two, I feel like ending on the law, which I think should be a very casual, conversational, laid back section, is not, I think, best for the end of your closing, which is, I think, dramatic and should be like kind of the 10 moment and the star of the show of the entire opening. So.
And I think that's a good point, because sometimes when you try to mess too much with that formula, you start to prove why it is the way that it is. It's almost like an if it ain't broke, don't fix it kind of thing.
100%. 100%. But again, like I think that like openings still look vastly different.
Oh, so, yeah, for sure.
That gives you so much, there's still so much flexibility there that I think depends on
let's break down each of those three parts. You start your opening with telling the story of the case. Again, if you're plaintiff or prosecution, that's usually saying what the defendant did. If you're the defense, it's usually, hey, here's what really happened. Here's what they missed. Here's the story from our perspective. And one thing I talk about in my book is, you know, it's not just a statement of facts. It's not just a list of things. You're telling a story in the same way that, you know, J.K. Rowling tells the story of Harry Potter, or you know, I don't know, Suzanne Collins tells the Hunger Games, right? It's interesting to listen to. It's captivating. So what are some of your favorite strategies for telling a good story during opening?
Yeah, I think that's a really good question. I think that the first minute and a half of your opening is honestly the most important part of the trial, honestly, in a lot of ways. Because if the jury doesn't have a good story and a clear, not only a clear story about what happened, but a compelling story in your favor, then you're just, the trial's a loss. And I think that it's interesting, because I feel like as I've competed, especially in college, the preferences of what like a good intro has changed, but I think that there's a lot of merit in like a lot of the different kinds. I feel like right now, mock trial is very in this extremely dramatic, just storytelling, just starting at a very specific moment from like in the case. So like, I think I just did trial by combat this past summer, and like my opening, we spent like the most of our time choreographing the openings, and specifically the first minute and a half, which elaborate, like spaced out, almost recreation, almost like a play of like this assassination that occurred in a public square. And I remember at the end of the trial, a lot of the judges were like, I really appreciated that section specifically because you really painted what it might feel like to feel anxious in like a shooting, a mass shooting, and like what that must feel like and how that would implicate how the detectives would look at the case. And that was literally just me saying, like, it's July, whatever, 2020. My client is like here freaking out, yada, 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 whatever. And telling this story, and you have movement and you have physicality. Like there was a sniper in that case. I literally like choreographed with my coach, like for like literally an hour, about how I was going to properly hold this like sniper rifle in my hand so that it looked accurate and like realistic. And it's those tiny details, I think, in those like very peak storytelling introductions that make them very, very good. And I think they're effective because they bring the jury into the heart and the emotion of the case, I think, so quickly, while also giving them a clear sense of what happened. I feel like the converse of that I also really enjoy is like more witty introductions. And I think that oftentimes like they get a bad rap, but like I think that like one of my favorite examples of this is like, it was from forever ago, it was Yale in the year that they won, but I'm not on the side, they were in the final. And it was this copyright infringement case. And this attorney, she gets up and she starts her opening, and it's about copywriting a play. Like someone infringed on a copyright of a play. They copied the play, like stole it. And she just gets up and she goes, if I went into work tomorrow and my colleague, Miss Bays, who's the person sitting at counsel table, her co-counsel, wearing the same shirt as me, I probably think that's just a coincidence. But if I came into work the next day and Miss Bays is wearing the same shirt and the same jacket as me, I probably think that's just a coincidence too. But if the next day Miss Bays comes in wearing the same shirt, the same jacket, the same hairstyle, the same dress, the same shoes, the same necklace, the same socks, I'd probably ask, what's going on?
Yeah.
I'd probably turn to Miss Bays and go, Elizabeth, are you copying me? Because when two things are so similar, it's just hard to believe that it's just a coincidence. And that was their whole theory. That like these plays were like the exact same thing. And so it doesn't even make sense that it wouldn't have been copied.
And that's such a great example of what we were talking about a second ago with taking the formula, right? Story, preview, call to action, and working within that, but also not making it square, not it being the same open over and over again where we just, change the names to protect the innocent, right? You can wiggle around within that formula.
Exactly. And I think it can be suited to the person. Like, I think someone that wants to do a super dramatic storytelling, like J.K. Rowling-esque, like very imagery based, like opening is going to be very different than someone that wants to tell a witty analogy that's very cleverly written to like get to like the moral push of your case. And I feel especially helpful when the case isn't particularly dramatic. And it doesn't really make sense to perhaps like in a copyright infringement case, what are you going to get up and say like it's opening night and he realizes that it's the same play? Like, no, it's not the same gravity.
Yeah.
A murder or like a bank robbery is the current AMTA case. And like, I think that's when those like more witty and like kind of conceptual introductions that the jury, but like when I say conceptual, it's not supposed to be complicated because it's supposed to be simple. That was a simple like metaphor, an analogy. Like it was not very complicated.
Yes.
So I think like common sense and like good introductions to like your theory, I think can also be good. And I think it's especially good for defense and like criminal defense openings too.
Now you mentioned the phrase a minute ago, the heart of your case. And one thing I always talk about is when you have a theme, which if you don't know what a theme is, it's a slogan, something very memorable that you put into your opening and try to weave throughout your case that, as I like to say, gets to the heart of your case. We won't get into a diatribe on what a theme is or isn't, but where do you like to put your theme in your opening statement? Obviously throughout, right? But I've seen the examples over and over again, and I've done it over and over again where you walk out into the well of the courtroom and you just start by saying your theme. And then I've also seen it very effective, probably what might have happened in the story you just mentioned, where you hold it off for a minute, you add a little bit of suspense. Where do you tend to want to put that? Because I tend to think, wherever you put it, it just at least needs to be obvious what your theme is.
I think the last thing you said is especially true. I think wherever your theme is, it has to pop and it has to be obvious and clear that it's a theme. I feel like for opening, for me, I think that with some exceptions, the rule for me is that it should be the first thing that just because I think mock trial judges oftentimes are coming in with like varying levels of familiarity with mock trial. But I think like having a theme is like one of those things that's very like par for the course for like the average mock trial judge. And it's going to be something that they're looking for. And honestly, it doesn't even have to be that amazing. They're honestly just looking for you to have one. So you ticked off the box of like having a theme.
Yeah.
Right. And I think the rules of primacy and recency, the idea that people best remember the things that they first hear
exactly
and last hear are very important. And in that sense, if you want your jury to remember the theme, it should probably be the first thing that you say. So that's kind of how I feel about it. I feel like generally it should just be in the beginning.
And, I've seen it done well both ways, but where I kind of got to the point where I lean towards starting with it is when I was in college. It was the AMTA case. You'll remember this one. It was about a wine poisoning, and our theme on one side of the case was this wasn't a case of sour grapes. It was a case of bad blood. Little corny, but that's what the theme was. Well, after the round, we get our comments back, and a judge had written in, "Man, I loved your guys' theme. One sour grape ruins the whole batch." And we all kind of went around and were like, was that said at any point during the trial? The answer to which was no. So I read that comment. I thought, gee, maybe you should just start by saying your theme so that they don't think it to be something that it's not.
No, 100%. I think especially if it's one of those themes, like I feel like a lot of times, like when we couldn't think of a good theme, like I've heard themes that are just statements, like he had nowhere to go, like
Yeah.
last option, like things like that.
Yes.
Like that's not memorable, and that's not that bad. That's fine. Like it's okay.
Uh-huh.
It's for the purpose of a theme, but that just means you have to do a little bit extra legwork to make sure that the judges remember it. And I think beyond
Yeah.
just saying it first, I feel like the biggest comment that I give that my coach, Sarah Steppets from high school, and then also a little bit in college, used to like scream at me all the time, was pause after your theme.
Oh yeah.
Please, just like, and not just a baby pause, a
Mm-hmm.
gaping pause.
Well, we're
Like,
gonna talk. We're gonna talk about pauses later on. I've got that in my notes, and I've also got movement, which you were talking about earlier. So
yeah,
we'll get to both of that. The next part of the formula of an opening statement, the preview of the trial, and what I like to just say about this is do as much as with little as you can. And what I mean by that is, as you're explaining the law, use as few big words as possible. You know, if you're introducing the burden of proof, say preponderance of the evidence one time, explain what that is, and then for the rest of the trial, call it the more likely than not standard. You know,
yeah,
if you're introducing witness names, we don't need to know Dr. Jacob Jinkelheimer Smith, right? No one's going to remember that. You can just say, you know, Dr. Smith or the doctor or the expert, right?
yeah.
As much as you can accomplish with as little to avoid overwhelming and confusing people.
Yes, I think that's super big, and I feel like the names thing is something that is not like I feel like people generally would agree that it's probably good practice, but I feel like in the average opening, there's a lot of names usually.
Mm-hmm.
It's not just how we because we know the case, right? So like
Exactly.
we know who these people are, but literally when I was judging around this weekend, like there was one opening that had a lot of names, and the other opening where they were saying the investigator and the expert and
Yes.
and
Mm-hmm.
the agent and the eyewitness or the
Yeah.
broker, like whatever it is, right? Like, and that's so helpful for me because not only is it like easier to remember because it's not super specific, but like
Mm-hmm.
it actually tells me what their role is
I
in
know what an investigator is. I don't know what a Shelby Jenkins is or a Tom Hanks or, you know, whatever.
exactly. And like it's so much more helpful for the jury. And I think the same thing goes for the law. I generally agree with you. Like I totally think that it should be just simple and that you just need to say the buzzwords once so that you can check the box, you know.
Mm-hmm.
You say burden of proof, which is not a very layman's term, but you need to say
Yeah.
it.
Yeah.
Like you need to say like all of those like buzzwords. But I think that all legal sections need a common sense explanation of what the elements
Oh,
are.
yeah. I mean, I'm thinking right now of an opening where the person tried to give a legal treatise on the difference between direct and proximate cause. And I'm just sitting there rolling my eyes because I'm like, no one is listening to this right now.
At all. At all. And they're not going to remember it either.
No.
Especially not. And I think that also, and I think also the other thing about that is that like on opening, you don't want to be talking about the law for that long and getting like really nitty gritty into like the specifics of the law because you'll get a judge that's like, why are you arguing the law right now in an opening?
Yes.
Like,
Mm-hmm.
like you're supposed to just preview the
Yeah.
law. You don't even know what the charges could be by the time you get to the end of the
Mm-hmm.
trial. Like you don't know what the jury instructions are going to be.
Yeah.
You know, like it's just a little crazy that someone would go like talk 3 minutes like in their opening statement about like a legal issue. Just save that for closing and
Yes.
like let your closers do that. And not to say that I think closers should give like extended legal diatribes.
Mm-hmm.
They should also be pretty
Yeah.
sense. But
Now that's a great segue into the last point I wanted to make about openings. And by the way, the reason that I wanted to have Travis on this episode was I put out a mock trial film sessions where we watched one of Travis's openings, and it's becoming one of the highest viewed videos on the Mock Trial Masterclass YouTube channel, which is crazy. I thought, is anybody going to watch this? But everyone loved it. And no wonder, it's a great opening. But one of my favorite parts of that opening that you gave at Trial by Combat, Travis, and you can go watch that video. I'll put the link in the description in the show notes, is, an opening statement is that it is a statement you were just talking about, right? We're previewing the trial. We're not arguing anything. But there are things you can do in your opening statement to clue the jury in on where you're going and already get them starting to side with you. Part of
Yeah.
that is your tone, and part of the ways you organize the way you organize information. And I thought it was super effective in that specific opening of yours. But that's something that I think is the hallmark of any strong opener is you're not arguing, and you would never even get close to being objectionable for that. But still, I listen to your open, and I'm like, yeah, I'm convinced.
Yeah. Yeah. And I think that usually for me, what that manifests in is like getting to the moral high ground of the case. Because I think that if you can tell the jury why you are morally correct, which I think you can often do without arguing, like that is what is going to really compel people. And I think that you've mentioned the poisoning case. I think a good example of that in our P opening, we were arguing negligence. So it was like the company was poisoning the wine, not like a purposeful
Mm-hmm.
poisoning. Um, and we had a very like profits over people ending, like in
Mm-hmm.
that,
Yeah.
like is not necessarily written into the case. Like, I mean, there's a little bit about like profit cutting, but it's not like that's like a major like theme, and there's not like crazy quotes, but it was just like
Yeah.
when companies like produce like things for us to consume, like we do that with like the expectation that they're going to do so safely and that they're going to do so without harming us. And when people break that trust and like breach that trust, like they
Yeah.
need to be held accountable. And I feel like that's not really arguing the law. It's just it's just telling the jury why you're morally correct, like why
Mm-hmm.
we're here in this courtroom today. And I think like oftentimes that's what, and I think that oftentimes can be in the dismount at the end, but it also can be in your intro, and it can
Mm-hmm.
also be woven in throughout your law, especially if you're like in a criminal defense opening and like your moral high ground is just like there's a burden of proof and they did a bad investigation,
Yeah.
like that's moral high ground as well.
I love that. I think that's really smart. I want to transition into talking about closing arguments. And by the way, I mentioned a minute ago my book, which I talk about all of this stuff in there, the sort of formula for opening, how to avoid your closing just becoming second opening, where you're just repeating stuff. We're about to talk about that. But if you want to pick up a copy of that book, I'll put the link in the description on YouTube and the show notes on podcast platforms. And it's written in such a way, guys, that, a lot of these college textbooks don't make any sense even to me. This is written for you guys, right? It's easy to understand. There's stories. We're going to have fun in this book. If you're liking this podcast, if you like these YouTube videos, you're going to enjoy the book. So go pick up a copy at the link, again, description on YouTube, show notes on podcast platforms. Travis, closing arguments, they need to be organized, but they also need to be responsive to what just happened. I can't tell you how many times in post-trial comments I heard a juror say, I loved that you were bringing in things that actually happened during the trial. I'm going to just ask you this general question, and then we can maybe dig deeper. And that's, how do you strike that balance? Because I've experienced with competitors, if you just say, go be responsive, it tends to be a disaster. It might sound good, but they'll either only talk about the witnesses that they interacted with. It'll be kind of hard to follow. But then if it's just entirely scripted, there's no room for being responsive. So how do you strike that balance in a closing? Because I think that's really hard to do, but also really important to do.
Yeah, it is. And I think that like that's why closing is one of those speeches that I think people really do grow into that speech, because I think it really is like at a certain point, it's like, at least for me, I felt like closing when I became more comfortable with like the general structure and I knew what a closing should always look like. I was a lot more able to just like know that I'm going to have three pockets in my closing, and those are going to be my three pieces of evidence.
Mm-hmm.
And I know that like I might talk about something else, I might bring up something else, but I know I need to go to that next pocket. Like feeling comfortable with that like flexibility, I think takes time because it's like stressful. And I think that improving is not, at least to me, I don't think it's the most natural skill a lot of the time. But I think that like more concretely, I think oftentimes what I see in closings is like a responsive section where like
I
they
like
have
that.
their like scripted portion and there's like a section that is responsive. And I think that's good because it's very intentional about like, I'm responding here, and jury, I'm signaling to you that I'm being responsive by saying, now let's get the other side's case, which is good. So I think like mock trial is like the enemy of nuance. Like you want to be very blunt, very, very clear about what you're doing so the judges know what you're doing.
Yes.
Um, What I think though is that sometimes the speech can sound a little bit stilted. Like you can hear someone that has this like very particular cadence for like the entire speech because it's super scripted,
And then they get into the responsive part and it
and it like
changes.
even like sometimes it's like even a lot better, and you can tell people off their script, so they're like feeling a lot more comfortable and they're getting into it and they're performing.
Yeah.
Like conversely, it's like it gets worse and it's like a little bit more choppy and like maybe they're stumbling over sentences more. And like, I
Mhm.
don't think that like stumbling over sentences is like the end of the world. That's like one of the things that I felt like I learned by the time I graduated, that like judges care more about what you're saying on the whole than like the fact that you like said every sentence correctly. But
Mhm.
I think regardless, like I feel like unless you have a comfortable closer, those responsive sections will come off stilted unless someone has experience doing that. And so for me, I feel like oftentimes when I like to help people be responsive, I think it's a lot helpful. I think it's very helpful for the jury and for the competitor to link the responsiveness to the points that they're already making, right?
Mhm.
Like a big thing that we try to do in our case theory and for opening and closing was, instead of like structuring your opening like witness by witness, was like having a conceptual like three-part framework, or that's three questions, or like before the crime, during the crime, after the crime, or why
Yes.
he did it, where he did it, when he did it. Like it
Mhm.
could literally be means, mode of opportunity, like
Yeah.
whatever you
Well,
want.
maybe something a little more clever than that.
Yeah, I actually hate means, motive, and opportunity, but like that's like the like most cliche version of what I'm
Yes.
describing. We try to have those consistent
I
across
like that.
opening and closing, and I think that's helpful. In opening, it's helpful because nobody cares about the order that your witnesses are going to testify in. They
Mhm.
care about how they relate to the points that you're making.
Yes.
And then you can put witnesses together if their testimony goes together, and you can bring in other kinds of evidence that you wouldn't be able to do like otherwise,
Mhm.
strict three witness structure. And I think in closing, that flexibility allows you to know what your general point is, and so you know the moments in the trial that will ostensibly like be important. And like you may not know like what will be said exactly, but like that if you're going to have a section about like how the medical evidence in this case goes in your favor, that there's going to be a cross of the doctor, and you have a very hard hitting cross, and they're probably going to, and maybe you've written your cross so that either they have to say no, which is a bad answer, or they have to say something stupid, which is also a bad answer.
Yeah.
And you can plan that out. You can literally say, you can have a section in your medical evidence section where you're like, and then I asked the doctor, like, blank question. And what did he say? You can't put the answer in your speech because you don't know what it's going to be, but you have
Uh-huh.
everything else leading
Mhm.
up to that. And I think when you are including it in your broader points, because then if you're in a point, you can bring that back to like, you know why he said that? Because of this point that I'm making right now, and like the ultimate conclusion. Like if you can bring it back to why that responsive moment is like actually important to the case, instead of just saying we crossed this witness on this, that, and they had all of these bad answers, and like a response
Yes. Yes.
that isn't really tied to like why that's important. I
Mhm.
want I want you to bring me to moments in the trial that like will help me decide on the elements that like are clear, very clear and clarifying moments where like, yes, that you're correct. Like that is an exemplary moment of like why you're right on this particular point.
I love that. And I'm going to steal that with my team this year. The idea of structuring your closing in a memorable way, right? What she heard, what she did, what she saw, or something like that. And the
Yeah.
reasons I love that is, first of all, it forces you to listen throughout the trial, which is what we talk to our students about all the time. Even though we give you scripts, you have to listen because you can't be responsive if you're not listening. The number two is that it's going to be naturally memorable in the same way that a theme is going to be memorable, right? When you use that repetitive language, the things she saw, the things she heard, the things she did, right? Even if it was means, mode of opportunity, right? That sort of repetition, it's memorable. But also when you use that structure, it forces you to argue, which is a mistake I see a lot of maybe amateurish teams make a lot, which is that opening or closing argument just becomes opening statement number two. Opening statement is you're going to hear, and then the closing argument is just you heard. It's the opening statement repeated in the past tense. And when you structure your closing in this way, it forces you to actually go into the trenches and argue.
Yeah, because you have to think about what should go where, because they all are important to different parts of your case. And like
Mm-hmm.
having to do that mental legwork is like important for yourself as a competitor.
Mm-hmm.
One, people even have more flexibility to know what's important. So even if you need to bring in, if you have to like cut something else to talk about this really crazy moment in the trial that you weren't expecting to come up, you know why it's important, because you know why you were going to talk about this other thing, because they prove the same point, because they're
Mm-hmm.
all the same section, because that's what this section is about.
Mm-hmm.
And I think it does force you to really think about like why your evidence is important. It's not just, you're not talking about each of your witnesses just to talk about them. You're talking about them because they prove very specific points, and like maybe they prove very specific legal elements. Like there's so many ways to structure it. But I think that oftentimes like having that we call it a sub theme structure, is really, really helpful.
I love that. I think that's gold. And I think everyone listening, go apply that to your closings, because it's going to work. I promise you that's going to work. I want to talk about delivery now, things we can apply to opening and closing. We talked a lot about the content, what to say. Now I want to talk about how to say it. And there's really two things that immediately come to my mind, which is movement that plays into it, and also the power of the pause. We've kind of highlighted both of those things so far. And so I'd like to just dig into each of them a little bit further. Let's start with movement, because you were talking earlier about giving this opening at trial by combat, where you're sort of play acting the downtown scene where this assassination had taken place. And because of that, the jury was, number one, they were complimentary of you, but also in the moment, they probably understood the story a whole lot better. So what are some of your favorite tips for intentional movement? Because if I'm being honest, that was always something I struggled with. Not that I wasn't moving at all, but that the movement was sort of chaotic at times, just because I was so, I guess, harebrained in on the content and so excited to say the things that the movement just kind of got lost. So what are some of your tips for moving well during a speech?
Yeah, I think it's really, really important. When I was captaining, I used to say all the time, mock trial is 20% what you say, 80% how you say it.
Yeah.
That includes your movement, because honestly, judges are not supposed to score on the merits of the case. They're scoring on your performance. And that means how you perform it determines how compelling it is. And I think movement's a really big part of that. And I think that the big thing about movement is that oftentimes I feel like I feel like when it comes to mock trial performance in general, and also about movement, I think that it's very easy to get in your own head and think that you're doing too much, right? To feel like you're being really over exaggerated, or you're being too dramatic. 9 times out of 10, the average mock trial person that thinks they're too dramatic is not dramatic enough, usually.
Yeah.
Because
now we've both seen it go the other way, where, as I heard someone from Rhodes College once say, you can only score a 10 in mock trial, and you seemed to be going for a 20.
No, exactly. No, I think that's true. Like, you don't want to be like over the top, right? But like, and I think that's where the purposefulness comes in, right? Because I think oftentimes these very over dramatic speeches are like over dramatic in the sense that they're doing too much, and there's not enough discernment about like when you're when what you're doing and like why you're doing it, and why this particular like dramatic choice is the right one to do. And I think with movement, this relates to movement, because I think that acting out the downtown scene was extremely dramatic, and it was extremely detailed, and it was extremely like well planned, and like I felt silly a lot of the time when I was doing it. Like there was a time where like my coach was literally like, I need you in the moment that like the shooting starts happening and she starts looking for the shooter, you're literally going to like almost run up to the jury, like literally almost run up to the jury. And I remember the first time I tried to do it, I was like, oh my God, this feels so uncomfortable. Like, crazy. And then she filmed it, and it looked more awkward when I was like half running, trying to be a little dramatic, than when I was like actually like acting it out. And I think that movement is oftentimes about committing to the movement, which makes it look purposeful. And oftentimes like committing to the movement like may feel a little wacky, but I think that like if you're talking about a call, it's totally fair to use a banana phone.
Absolutely.
And it's like even small things like that are like purposeful, that are illustrating what's happening to the jury. If there's a long distance in the courtroom, say as you're demonstrate the long distance, say that he walked from here and then walk all the way over there. It demonstrates to the jury physically, purposefully, that this is a long distance. And I think that like it's movement, that kind of movement is really important, but not all of it has to be illustrating, right? I also think it's very fair to have like structural movement. Like I think this is especially important in opening. Like if you're going to have a sub-theme structure where you have 3 points, you should like probably go to 3 different places in the well during those 3 points, oftentimes in a line in front of the jury, right? You go all the way to the left, and then in the middle, and then on the right, or actually I like from all the way to the left, all the way to the right to end in the middle. And then like stepping back for like the very last part of your opening or stepping forward. Like, and I think that is also helpful because you're not necessarily illustrating something that's happening in the case. You're illustrating the jury your structure, like how you're arguing the case, which is equally as helpful. Like it's equally as helpful for the jury to know that there are 3 points that I need to remember. A jury member could be writing a point, look down, not really be paying attention, can look up, see that you walk to a different place and go like, okay, so that point that we were just talking about is over.
Yes.
I get it. I missed that point. We're on a new point now. I should pay attention. Right. And I think that like a lot of times movement and like also like, I think pausing is like this too, but we'll talk about that later. Like, I think, but like, it's very practical because like judges are writing comments and scoring you.
Yes.
Also trying to pay attention to you. And there are certain things that you can do to help them in that endeavor.
I think my favorite movement is I love to use antithesis in mock trial speeches. If you don't know what antithesis is, guys, that's, you're sort of contrasting two ideas, right? She said it was cold, but it was actually hot. He said the car was nice, but actually it was dirty, right? You're contrasting these two ideas. And when you're doing that in a speech, which happens in virtually every opening and closing, I love to have a spot where I stand for the good stuff and then a spot where I stand for the bad stuff. You're standing in one spot and you're saying, maybe you're on defense and it's a criminal case and you're saying the government just got up here and they told you this and they told you this and they said that the defendant did this and did that. But then you take a step over and you say, but what you're going to learn today through the facts is that this is really a case about this. And but Mr. or Miss So-and-so actually forgot to tell you such and such, right? I think that's really powerful. And above all, you made the point, Travis, that using your movement can help punctuate your speech. It can help the jury stay focused and not feel overwhelmed. And at the same time, I always say that the whole key to winning mock trial is controlling the courtroom. The team that controls the courtroom more usually wins around. And if you're walking around and owning the space, right, that plays directly into that.
100%. I think especially weirdly, I think this is especially true for closing, where oftentimes you have lots of high points, like lots of dramatic moments, lots of good lectures, lots of good moments to be dramatic, because they're oftentimes a little bit longer too. Sometimes, I think movement is just such a great way to just like create that like 10 moment in your speech. Like that moment where everyone's like, wow, you are a great competitor because you're owning this space right now. Like, I feel like as a closer, like I was known honestly for running around the courtroom when I was closing. Like even in my last closing at Trial by Combat, like I had this moment where like basically I was defending the defendant, right? And they had lied to the police because they were like worried about being blamed for the crime anyway. Right. And that's like their whole bit. They were like, I lied because I thought they were going to assume I was going to do it. And so I just wanted to get it. Like, I know I didn't do it and I lied. It's going to happen. And in that moment, I'm standing in front of the jury. I'm like, and the prosecutors want to ask you why. And then I like almost run to the back of the jury, to like the back of the gallery. And I'm like, and I put my arms all the way out, like Jesus hands, like, this is why, members of the jury, that she would be in a courtroom in front of 3 prosecutors, a judge, and a jury being tried for a crime that she didn't commit. And like, I remember people told me afterwards that they were like, that was the moment, like, of the whole trial when you like literally walked to the entrance of the courtroom and like back. And I think that it seems like a lot, but I think that like showing that you're willing to like use the courtroom and acknowledge that this is like an actual space, right? Like one of my other favorite uses of space is when people are talking about the burden or like presumption of innocence, when they're like, and when my client walked through those courtroom doors, and they go to the courtroom doors, they don't just point to them. They go to the courtroom doors. They say, when my client walked through these courtroom doors, they walk down the aisle and they say, walk down the aisle, sat on this stand. Like they act out. Like that is like so powerful. I think. And, like really demonstrates that you're confident and like, you know what this space is used for and you know what happens in this space and you like are confident in this space.
Yeah, that's huge. There's one more element about delivery that I want to touch on. Before we get to that, I want to make sure everybody knows I love sitting with teams and listening to their speeches and being able to tell you, hey, here's what you're doing well. Here's how you can make it better. Just last year, I was sitting with the team doing that, listening to some of their material, and we spent some time together, and they wound up going on to win empire. And so I'd be happy to do that with your team too. If you're interested in that, you can schedule coaching with me by clicking the link in the description on YouTube or in the show notes on podcast platforms. But one last element of delivery to talk about, and that is vocal variety and the pause. If you are monotonous in your opening or your closing or really whatever in mock trial, but specifically in speeches, I will stop listening if I am scoring you, and I imagine that others will too.
100%. And I think that manifests in like so many different ways, because I think on the one hand, you have perhaps the speech attorney that's completely monotone, and that's not very pleasant to listen to. But I think on the other hand, you have the speech attorney that has mastered a particular cadence that they're really good at, that sounds really nice, but you realize that they are doing that cadence on every single sentence. Mm-hmm. And by minute 2 of the closing or opening, you're like,
yes,
okay, well, I really like that you can do this intonation, but you do it on every, like, you know what I mean? Like,
yeah, exactly.
Sounding the same way on every sentence. Mm-hmm. And that's why I think variation, the name of the game when it comes to like speaking and like vocal techniques, is really just variation. It's always just about doing something differently. And oftentimes it does matter what like exactly how it is different. But I think especially when you're doing like repetitions, like sometimes I'll tell like people that I'm working with, like, can you just do the third one a different way? Like, I don't really tell them how to do it, but like, if you have 3 things in a list that all like sound similar, like she chose to do this, she chose to do that, she chose to do this, like all 3 of those should not sound the same. Like,
yes, like
they should not. And like, if they sound the same, it's going to sound boring. And oftentimes it's just a tiny change. It's oftentimes changing the emphasis of the sentence. Maybe it's emphasis on a different word. Maybe you use a higher register of your voice. Maybe it's like on a different rhythm. Because I think that like a very like almost in a very musical way. I was in an a cappella group in college, so like I sang a lot. So I felt like I think of it like that, like having variation, like literally using all of the parts of your voice, like using the high parts of your voice, using the low parts of your voice, using the quiet parts of your voice, using the loud parts of your voice.
Yeah. I think what always has come natural to me as just a speaker in general is the range of the voice in terms of getting really, really excited and really, big point. And then here's the not so important point. What I have struggled with is the volume. I tend to just want to be loud and be loud the whole time. Yeah. But one thing that I've learned, like you were just talking about, is it's not just about the range of your voice. It's also about the dynamic, the volume of your voice.
Yeah. 100%. I think that like an intense whisper in a speech, like, can be extremely powerful.
Oh yeah.
Obviously, like, and I think that on the whole, if someone asks me like, should I be quiet or loud in a trial, I would say loud. You should be projecting and you should always be heard. But I think that, and I feel like honestly, this is the theater thing, like projecting is not always sounding like you're speaking loudly. And that's a very hard thing, I feel like, to conceptualize, is that like sometimes you don't want it to sound like you're screaming, but like you need to like put the loudness out there. Like even like maybe you're not actually whispering, but it's like a lot, like it's definitely a different register of your voice, and you need to like project whisper, like a breathy like sentence, and that like, gives the effect of a whisper, but like while also being heard. And so I think that like having just moments of contrast are super important. I think contrast is super big too. Like I think the best moments are when someone's like getting really fat, like a lot faster and a lot louder, and then it breaks, and then there's a gaping pause, then they're quiet. Because that does 2 things. One, it's just dramatic and fun to listen to.
Yeah.
But 2, if your judge is writing notes and you have a gaping pause and you were just yelling, they're gonna go, "Whoa, what's happening?
Yes,
like, what just happened? Why is it quiet now? You were just yelling." And it gets their attention back on you. And
the thing about the pause is a lot of young students who I coach will be uncomfortable with the pausing at first because they feel like it's awkward. They feel like they're just leaving the blank air. But when we were watching your opening, Travis, for that film session video, I think I counted like 8 or 10 seconds at one point. You just stood there. And one thing I pointed out to the audience was, hey, no one, when you were watching that, you didn't go, when's he going to start talking again? This is awkward. You were like on what really happened is you were on the edge of your seat waiting for the next word. Yeah. And I think it's important to pause like that throughout your speeches, right? As you were saying, to punctuate your important points. But here's where I think the pause often gets forgotten, and I think is super important to do. And I think you'll agree with me on this, which is, okay, we finish our opening, we repeat our theme. We're going to ask you, find the defendant, not guilty, thank you, and then we run back to counsel table.
Yeah. That is one of my pet peeves. You got to let it sit. You got to, I think that's a thing for speeches, but I also think it's true for directs.
Oh, yeah. Yeah.
Crosses. I think that like the ending of anything in mock trial should oftentimes be the strong, like the opening and the end of whatever you're doing, whether it's a direct, cross, or speech, should always be probably the best parts, because those are the parts that people are going to remember.
Yeah.
And you don't want to like ruin the moment and like detract from the gravity of this moment by like scattering out of the well really quickly. Like that's so like stand there. They're not going to tell you, they're not going to kick you off the well. Like they're not going to be like, sit down. Like they're looking at you. And like obviously, like if you put your pause like before you say thank you, like that's probably the best thing to do, so that like there's a reason you're standing up there. Like you're letting it sit and then you thank the jury for listening to you. I think that's oftentimes a good place to pause.
Travis, let's wrap up like I do with every guest who comes on the Mock Trial Masterclass podcast, and that is by asking 2 questions, because a lot of people listen to this show with varying levels of experience. I'm sure we've got some great competitors who are trying to get better, and I got a lot of people who don't really know what they're doing because they're new to this and they want to know what they're doing, right? They want to learn. And so I think it's important hearing from someone like you who's as accomplished as you are to hear from things that you've done in the past in mock trial that maybe didn't go so well. I think that can be comforting. So what I would love for you to share with us, Travis, as we close out is, what is your biggest triumph in mock trial? And also, what was your biggest failure in mock trial? This can be an award. This can be a literal accomplishment. We won first at nationals, which I know you did. Or it can be, I asked this dumb question during cross and the witness ran around on me or something like that.
Yeah. Oh, this is such a good question. So starting with triumph?
Yeah, we'll start with the triumph.
Okay. I think I would say that my senior year, the team, it was very interesting because we had previously the year previous had just won nationals, and that team, that A team had only graduated one person going into the next year, and one person ended up not competing, but the bulk of that A team was the same. And so whatever, the year's actually going pretty well, and we get to Orcs, which is like the nationals qualifying tournament in college. And I think for a myriad of reasons that obviously I think mock trial is a team activity. So nothing in mock trial can ever be attributed to one particular.
Oh, yeah.
But like, I think there were moments where like, I felt like I maybe could have done better, or like our theory could have been better, that like our team could have been better. But like, I think mock trial is also in a lot of ways about luck a lot of the time. And
it can be, for sure.
Wins call it, like if it just falls in your, if the chips fall in your favor, like it's just, sometimes like, and I think that really like is manifested concretely in like, sometimes judges have different preferences. Sometimes judges hate character witnesses. Sometimes like judges love character witnesses. Like you don't know, and you don't know what those preferences are before you walk into the courtroom. And so like sometimes like I felt like pretty handedly like that we won a ballot, and like we could have lost it by 15, and like that was because the judge like doesn't like dramatic mock trial, which like fair, you're the person that was assigned to judge this round, and like it was my job to like make you think that I was good. So like it's just, that's just how it happens sometimes. But what ended up happening at that tournament was that our B team ended up getting a bid to nationals, because we had 2 teams at the tournament.
Okay.
And I remember being so emotional when that happened, because like we hadn't gotten a B team to nationals in such a long time, because I think the team was in like varying straits of like distress, like in multiple years. And just having the program like consistency to like be able to get a B team through to nationals, which is a really big deal, was like so meaningful. And I remember I started crying like instantly, and I was like so happy for them. And then the very next thing we realized is that our A team did not get a bid to nationals. And I was a senior. I was graduating that year. And like, I was struck with the reality that like, I was doing trial by combat over the summer that had been confirmed, but like, this was like my last, like that could have been my last like team tournament ever. And it's just really crazy because the way that year turned out is that we ended up restacking, and we ended up doing like half of the A team members, half of the B team members. And I was just it was very emotional because in a lot of ways, I felt like I was back like 2 years ago when I was coaching a team of like all freshmen and sophomores again. And like, but not in a negative way, but like that energy that we had and like that desire to like want to like prove like ourselves that like, there, like, I like had to feel that again, like as a graduating senior. And then we ended up winning our division and going to the final round. And I remember my disbelief, like the day before the fourth round, at the fact that we were in the high round 4 pairing. And I was like, there's just no way that like we could have been this lucky to like have experienced that. And I feel like that was kind of both of them in one. I feel like my biggest failure was definitely like that feeling at Orcs of like feeling like that I could have done better, and that like it would have been an even better feeling to have gotten 2 teams to Orcs and one and had to restack. But then the fact that we were able to like figure it out and like come back together as a team and like just do what this activity that we love. And like we didn't even win the final round, but like I think I was arguably prouder in some ways my senior year when we would play second at nationals than my junior year, because I think the path to get there was a lot more tumultuous. So
I want to ask you a follow-up question on that, which is, how do you as a leader, whether you're in the position you were where you were a student or whether you're a coach, how do you as a leader handle when you have an A team and a B team and it is stacked and the students know that? And, you know, I believe to be unclear is to be unkind. So yes, there is an A team and there is a B team. We're not making bones about that. But and you know, give your A team every chance you can to win, because that's where you're pouring your resources, but not make your B team feel lesser or feel like they're just kind of the scraps and being thrown to the wolves. How do you strike that balance as a leader?
Yeah, I think the most important thing, and I think that on our program we only ran 2 teams, and the reason why, for a long time it was because, and still is because you can only take 2 teams to nationals. So you can run more teams, right? We could have had Harvard A through F if we wanted to, but like, only Harvard A and B can go to nationals. And I think that the most important thing was just having this tone and this expectation that like, yes, there's an A team and a B team, but the whole point is that you're on this team that is competitive and like will be like is going to do good at mock trial. Like we are a good program. And like I think that like that's a very important perspective to have, because I think that it's bad to like go into a B team scenario, especially when it's possible to like qualify multiple teams. Like it like actually is a like logistical, like practical possibility of the tournament, like NAMTA. Like I just think going into it like, oh, like it's B team, like we should like not try as hard as A team is like always going to set you up for failure, because like the only reason A team is doing well is because they're like, they think they can win. So they're practicing a lot and they're doing this stuff. And like, I think mock trial is like much more about hard work and consistency than it is about some natural, like God-given talent that like have. And I think that like my senior year, that showed that like our B team that was like primarily freshmen and like a few sophomores like worked their asses off and like got a bid when our A team didn't. And I think having that perspective and like making that the motivation and like that being the like general ethos of the team is really important. And I think also just like expending equal resources. Like obviously when I was on the team, like when I was captain, I was the captain of A team when we then like stacked. But like a big thing was that like the captains are expected to go to B team practices every so often and so like help out and like give them support also. Because I think that like it may feel like, oh, it's just B team, but like B team members are future A team members.
And that team unity is so crucial. I've seen that play out over and over again.
Exactly. And like these competitors that like maybe just B team members to you are like going to be the juniors and seniors of this program in 2 years. And
absolutely,
so you are wiser for probably trying to impart as much institutionalized knowledge as you can. Like I feel like that was my biggest thing my senior year. It was always just like trying to say like, this is how we've been doing, like this is how we do this. And like we should tell B team that we should start doing this and like we need to codify it and like all these things that I felt like we had learned as a team in this cohort from like my junior year to my senior year. Like we wanted to like make sure that they were imparted down and like they were solidified.
That's great. I love that. Travis, thanks so much for hopping on. I think a lot of people are going to get a lot of help from this. And I'm excited to hear stories from people who listen to this and go and give great openings and closings.
Oh my God, I hope so. Thank you so much for having me. It was so fun. I love talking about mock trial. I think we all know it's such a great activity. So I hope it's helpful. But, listen to your coaches always because they know what's best for you.